Hello, and thank you for joining us for today's virtual education program at Cancer Support Community South Bay. I'm Rebecca, the program manager, and I welcome you to this workshop titled Getting Your Affairs in Order. Before we begin, if this is your first time joining us, CSC South Bay's mission is to uplift and strengthen people impacted by cancer by providing support, fostering compassionate communities, and breaking down barriers to care. Our vision is that everyone impacted by cancer receives the support they want and need throughout their experience. We serve the South Bay, Long Beach, and Orange County area all at no cost. Our program includes support groups, networking groups, healthy lifestyle classes, social activities, and educational programs like this workshop. Educational programs are open to all. If you'd like to hear more about our services or join a community, please visit our website at cscsouthbay.org. Before I introduce today's speaker, we ask you to keep your microphone muted to eliminate any distracting background noise. Please feel free to enter any general questions into the chat function found at the bottom of the Zoom window, and we'll get to them after the presentation. Without further ado, I'll introduce our workshop speaker. Eric Harris is a partner at Pacific Coast Legacy Partners, LLP, with offices in Torrance and Manhattan Beach. He is board certified as a specialist in estate planning, trust, and probate law, and is a member of the LA County Bar Association, South Bay Bar Association, past president of the South Bay Estate Planning Council, past co-chair and member of the Professional Advisory Council at Torrance Memorial Medical Center, and is currently a member of our own Professional Advisory Council here at CSE South Bay. Thank you so much, Eric, for being here with us today.
Thank you. First of all, just wanted to see if everyone can see the slides.
Yes, thank you.
Okay, good. All right, so we're going to talk about getting your affairs in order and estate planning in general. And if you have questions, maybe you could type them in the comments, or you can raise your hand and we'll take questions at the end. If you type them in the comments, we'll just let the comments build up and then we'll handle it all at the end, if that works. Okay, so why do people need to get their affairs in order? Well, if you don't do it, you leave a big mess behind. And, a lot of people do that. A lot of people leave a big mess behind. And it's not very nice. It's not very fun. It's not very nice for the people you care about. It's a little bit thoughtless. Sometimes it just happens, if someone dies early, but if you think you might pass away, it's a good idea to get some planning done. And guess what? We all pass away at some point, right? So, in other words, we should all get something, even if it's a simple situation. We should still get something. Okay, so first bullet point there, we have estate planning issue. So in California, the probate process, meaning when you pass away and you just have a will or you don't have a will, under the law, your estate, what's left over, goes into the probate court typically. There's a few ways to get around that. You could add a beneficiary to a financial account, like TOD or POD, something like that. That'll avoid probate. But for real estate, there's really no way around it unless there is a transfer on death deed that doesn't work very well. Maybe it might work just for one person, for example. It doesn't work well for multiple children. But anyway, the default procedure is your assets go into probate, and California probate is very difficult, expensive, and there's a lack of privacy. And for example, the attorney fees and executor fees for a $1 million property going through probate are close to $50,000 that has to be paid out. And it's better just to do some planning so that you could avoid probate and avoid all the court costs and the attorney fees. And I often wonder why California makes probate here so difficult. And maybe it's so that people so it scares people to do their private planning and not rely on the public court system. But I think the real reason is California is very protective. They're very protective toward all various parties involved, like, children, minor children. They're protective toward creditors of a deceased person. And so they want to let everybody have their day in court. And as a result, you have a long and expensive probate process. Um, what's a conservatorship? Well, a conservatorship is so if you become incapacitated and you don't have powers of attorney set up, a conservatorship is something set up by a court where the court oversees your incapacity. So if you become incompetent, if your brain stops firing on all cylinders, you start to lose too many marbles and you don't have your power of attorney set up, and these are easy documents to set up, inexpensive as well. But if you don't have those set up, you could go into a conservatorship. And that's no fun. That's a court breathing down your neck and lots of unnecessary red tape. And then, the third bullet point down, we have sometimes you have a loved one and it's not a good idea that they inherit something outright. They might be hooked on drugs. They just might be bad with money. There's all kinds of issues. That kind of leads us to our next bullet point, protecting a loved one from lawsuits, creditors, and predators. Maybe somebody is married to their future ex son-in-law or daughter-in-law, right? It's maybe there's a bad marriage involved, and or somebody has a really risky job. Maybe they're a doctor or a lawyer or a business owner. Maybe they can get sued. So you can also set up an estate plan to protect your heirs or your beneficiaries from themselves, from other people who might sue them, from their future divorcing spouse, all those things. But the main reason people set up an estate plan is to avoid probate. That's the main reason. And they do incapacity planning because almost everybody's going to die, right? So far, I'm still waiting for news about that we're not going to die, and I keep hearing that it might be possible, especially with AI. So, but so far, not we're not there yet, right? So, okay, all right. There's other reasons. There's all kinds of tax issues wrapped up with estate planning too. Um, there's an estate tax. Now you have to have more than $15 million to even worry about an estate tax these days, but the laws could change at any time. I don't think the laws will change that much. I'm a little bit cynical because both sides of the aisle in Congress are wealthy now. They do a lot of well, the president and Congress are all wealthy. Both sides. I'm not being political here. I'm just saying there's not a lot of incentive for Congress to lower the estate tax exclusion. And so you can pass away with $15 million. There's no estate tax. If you have less than that, you don't really need to worry about that right now. But I think more importantly, there are a lot of income taxes and especially property taxes in California that we have to worry about. So we all have Prop 13. If you own real estate, you're under Prop 13, and that keeps your property taxes low, especially over time. And so you got to really kind of think about that. Another reason to do planning is blended family issues. So this is a Brady Bunch scenario where, there's children from different marriages, from prior relationships. And you kind of have to provide protection in case, depending on which spouse dies first, and there might be separate property issues instead of marital issues. If there's a lot of money at play, we can set up vehicles to transfer a lot of money without future estate tax. That's multi-generational tax planning. Any planning we do, I think, should be designed to promote family peace and harmony. Uh, So, when you transmit your legacy according to your wishes, like I think, you know, that's the most important part of why you do everything, right? Um, People always talk about the nuts and bolts of estate planning, but what about why you do it? You know, you do it because you love and care for your family and loved ones. Yeah, and so, that's a big part of it. And so doing your estate planning is taking into consideration those things and trying to work that into your estate plan as well. Okay, so tax planning issues at play. Um, so a lot of times, I hear people say, why can't I just put my kid on the deed to my house? Well, these days it could create a problem. If your kid doesn't live with you, it could create a property tax reassessment potentially. Uh, and that's as of 2021, they changed the law about property tax reassessments a bit, and it made it a little more difficult there. But sometimes that could happen. Um, but I think one of the biggest issues is you want to plan for a full basis adjustment when you die. Meaning, if you own your house entirely when you pass away and don't put your kid's name on it, when you die, the house will receive a complete basis adjustment. So let's say you bought it for 100,000 back in the 70s, and then you pass away now, and the house is worth 1 million. What that means is that your children can sell the house right after you die, and there's no capital gain tax because the basis steps up to $1 million as soon as you die. That just means there's no capital gain tax. Whereas if you tried to sell it before you die, there'd probably be a capital gain tax. There'd be some exclusions that would reduce the tax, but if you bought it for 100,000 and you sell it for 1 million, there's probably going to be some capital gain tax. You don't have to worry about capital gain tax if you die owning the property. So to preserve that full basis adjustment, you will want to um, own the property completely before you pass away. And then you could send it through a living trust, or you could pass it through your estate. Not recommended generally. It goes through the probate courts. Whenever you die, it's going to get a basis adjustment, but that all depends on how much you own. And so for the parents who put their children on the deed, they lose that basis adjustment to some extent. We already talked about the estate tax. Um, so I'm going to kind of just uh, skip over that one. If you have questions about that, let me know. It just doesn't impact that many people. Property tax. So as of 2021, you can transfer your principal residence to your child, and the exclusion is 1,044,586. That's going to be exclusion, I believe, until next year, plus the current assessed value at the time of transfer. Now, the assessed value is not the market value of your house. The market value of your house is something totally independent. The assessed value is the little numbers that says assessed value in your property tax bill. When you get your property tax bill, it'll tell you what the assessed value of your house is, and that's for purposes of Proposition 13 in general. And you would look at those numbers, and it might value the land and the building separately, but you tally those up, and that's the total assessed value. And when you apply 1.25% to that value, that's how your property tax is calculated, generally speaking. It's not exactly 1.25, but it's close. So if you look at your property tax bill and you figure out the assessed value, and then you look at 1,044,586, that's the total exclusion that the county assessor will give you as of 2020, as of this year, but this is from the new law stemming from Prop 19 that passed in 2021. Prop 19 really affected the transfer of property from parent to children. We used to be able to transfer many, many properties from parents to child under the old law. But somehow this new law got snuck into a proposition, and I think most people voted for it, not really understanding what it was all about. It was in the fine print, really fine print. So it really scaled back, um, the reassessment protection. So if you do have rental property, nowadays it's a good idea, uh, especially if you have multiple children, and you're married. So that's even better. If you're married and you have multiple children, it's better to often have an LLC because we can do certain techniques to perhaps avoid a property tax reassessment using LLCs only and not worrying about the parent-child transfer situation. So that might be on someone's radar. Also, if you have multiple children and one wants to inherit your house and the other one doesn't, and your house is your most valuable asset that you have, it's really important that you talk to your lawyer about putting a real estate option into your trust so that your one child could buy out your other child using his or her own money. Because if you don't have the real estate option in there, it's going to be a lot more expensive to try to keep the property taxes low. Because the county assessor, and this is per the State Board of Equalization that manages all the county assessors in California. The State Board of Equalization says that's a sibling to sibling transfer if your kid pays your other kid for your house. So the only way to get around that is real estate options in your trust. So talk to your lawyer about that, make sure it's in there. And then there is another way, which during the estate settlement process, the trustee has to get an expensive bridge loan against the house, and I won't go into detail too much, but it's expensive and it's unnecessary if the lawyer just puts some very simple, even one line into your trust about a real estate option. So save a lot of money and headaches by trying to get that in there. Okay, so what are the foundational estate planning documents? Uh, so a living trust is still the gold standard. Like I was saying, you can send real property through something called a revocable transfer on death deed. It's almost like a pay on death for a financial account, and it might work well if you just have one child and you don't want to spend the money to set up a living trust. There's problems with it trying to deal with that if you become incapacitated and your situation changes, and there's problems with it if you have multiple children. But if you just have one child, maybe that will work. So I can help you, set that up if you have one child and get that recorded at the county, this transfer on death deed. But most people they want a little bit more protection, so they set up a living trust and they have a will that goes with their trust. And what the will does is the will is a pour over will. So the will says, I leave all my estate to my living trust. That's all it says. Now, the goal is to not have an estate at all, but sometimes people forget to put something in their trust and then it's sitting out there in their estate. And then we could usually avoid a full-blown probate if we have a will saying that it goes to your trust. Um, you want to have a power of attorney for finances. So that's, if you hear the word springing, that just means, okay, this power of attorney springs to life when you become incapacitated. But a lot of times these can be made so they're active immediately. So you just hand it to the person. Um, let's say you're getting old and you're like, well, I need help anyway. I haven't lost capacity, but I need help. And you could just hand it to them and you don't have to be ruled incapacitated by a doctor first. So a lot of times I do both of these for my clients. I'll make one that's springing. I'll make, kind of a one that has more powers in it and make it springing, and then I'll have a smaller one that's active immediately. All right, then you need a power of attorney for healthcare. This is the Advanced Healthcare Directive. You can get this online for free. It's and then you might have heard of a POLST. A POLST is a physician's order for life-sustaining treatment. And that's something that most people will only set up when they're in the last 6 months of their life or so. That's kind of got a DNR in there. It has a doctor's order to do not resuscitate if you just happen to pass out. And, it's for people who are kind of facing the ends. I don't know if you really need a pulse, um, but a lot of times if you go to assisted living facility or nursing home or something, they'll want you to sign one. And then you can nominate guardians for minor children or a conservator for yourself. Like I was saying, you set up these powers of attorney to avoid a conservatorship, but sometimes you need a conservatorship set up anyway. So so anyway, these when I say sometimes you need one anyway, sometimes you will fight against your documents. Some people will lose their minds and they say, no, no, I don't want the person I have set up in my documents to do this, and they might be demented or something like that. So sometimes a conservatorship is required anyway. Okay, so how do you start the process of estate planning? So first, make a list of what you own, how you own it, and the value, and back up your list with third-party documentation. So, for example, find the deed to your house. Okay, and then on the deed it shows how you own it. Do you own it in your trust? Do you own it individually? Do you own it with other people? Are you a joint tenant? Are you a tenant in common? Um, all those things are important things to know about how you own your house. Um, how do you own your bank accounts? Is it a joint account? Is it an IRA account? Is it a taxable investment account? Is it a 529 account? Um, and so you always want to look at the third-party documentation and also the titling verbiage on that as well. And then you just make a list of that, and that's a good place to start. So second on this list, and this is underrated, this is probably the most emotionally difficult thing for my clients who work on estate settlements to have to deal with is everybody's personal effects. You wouldn't believe how many people have just so much stuff packed into their house, and it's so hard on the people you leave behind. So one thing I would tell you right now, organize your stuff, get rid of most of it. You don't need so much of your stuff. Uh, Constantly, I've set aside one day a year or a couple days a year to just review everything that you own and say, do I really need this useless thing? No, I probably don't. But so many of us turn into collectors and we just collect and just cram every nook and cranny of our house full of stuff. And this presents a huge problem to those you leave behind. Um, all right, and we talked about transmitting your legacy. So you may have heard something called a ethical will. And what that is it tells the reason why you're doing something. So you set up your estate planning documents that show how it gets done. And that's what you can do with a lawyer, but only you know why you've done this. And so a lot of times my clients will write a letter and they'll say, hey, I'm leaving you this inheritance because I love you and because I want to, because I'm perpetuating my values of unconditional love, hard work, and whatever. And and all of those type of value statements are incredibly valuable for your family and loved ones. Um, and then you should, of course, work with professionals that complement and meet your style. So some of you on this call are do-it-yourself people, and that's totally cool. And I respect that. And you know, in my law firm, for example, we have a fairly low priced estate plan package that's made for do-it-yourself people. We just create the documents, we file the deed to your home, and then we give you general instructions. You handle all the rest. As long as you can follow simple instructions, you can do it. And then we have other clients who say, you know what, I want you to hold my hand through the entire process. I want white glove treatment. I want you to just be there at my beck and call through whatever I need. And so we have a program for those people too. So that's the do it yourself or the delegator. And you have to figure out what kind of person you are. You want to do it yourself or you a delegator? Do it yourself, you save a little money. Delegator, pay a little bit more money, but then you don't have to worry. Okay, so when you set up an estate plan, do you set it and forget it, or are you hitting a moving target? Well, obviously you're hitting a moving target because what changes in your life? Everything changes. Your money changes, what you own changes, your health changes, your family situation changes. A lot of stuff always changes, right? So the best way to do that is to track um, track the title, characters, beneficiaries, valuations of your assets. Um, you should be able to find the lawyer who can help you add things to your trust and designate beneficiaries if you need that help. And, you know, also work with a lawyer who can provide you with some kind of maintenance program so that you can just make changes without worrying about a huge legal bill. You know what the average hourly rate of an estate lawyer is in the LA area? Uh, it's really high. So if you go up in LA, the average estate lawyer makes between 800 and 1200 an hour up there. Down here, it's a little bit lower in the South Bay, but it's still very expensive. And so just having one quick call with your lawyer, it can be extremely expensive. So some firms, like my firm, we offer a relatively inexpensive program. So if you need to make changes, you can get it done. And it's all like under $1,000 a year. So, all right. So we got that. And I think we're at the end here. We covered first steps, getting organized, what kind of documents you should get, the tax issues, probate avoidance. I think we're ready to take some questions. It's been about half an hour or so. Let's look into the chat here. Okay, so first question is, do you still need a medical letter for a springing power of attorney? So the answers to that question is maybe. So most springing powers of attorney and also complementary provisions in a living trust will state the conditions whereby you're determined to be incapacitated. So that could be a doctor's letter, or it could just be a letter from your agent listed in your power of attorney. Your agent can, your kid, for example, can say, yeah, my parent is incapacitated. I'm stating this that they're incapacitated. But most people use a doctor letter because it's nice to get a medical professional who understands, okay, my dad or mom is unable to manage finances anymore. Okay, next one. We just had a workshop focusing on advanced directives, post, and dementia directives. Please check your Sunday program email. Okay. All right. Yes, exactly. So thank you very much. Let's see. Oh, and then you have a live workshop on decluttering. That is great. You know what? That decluttering issue has become way more important to me over time, just because I see the devastation it has on the kids who are just overwhelmed by, and they don't know where to stop. And especially if they have OCD themselves or something, they just shut down completely. Okay. Next question. Do the Prop 19 basis adjustments apply if you have a living trust? Yeah, so all they really look for is this a parent-child transfer? And you could gift a property to a kid, or you can die and leave a property to a kid through a living trust, through intestate, meaning you don't have a will and it goes through probate. Um, or via a will, uh, or through that revocable transfer on death deed. It doesn't matter how the kid gets the property. The parent-child exclusion will still apply, The only rule is that it must be filed and the kid must make the property their principal residence within 1 year of the transfer. So if it's a gift, they have to move in within 1 year of it being gifted. If it's a transfer on death, then they have to move in, at least one within 1 year. Um, and there's good. I hear there's legislation in the works to liberalize that 1 year requirement because a lot of probates are taking more than 1 year and people are blowing the deadline. So uh so they haven't worked all the bugs out of the system with that. So let's see, if there are no children to transfer property to, is there still an exclusion? So yeah, there's a few other exclusions. So if you create a joint tenancy, there's an exclusion there. There's all kinds of little tiny exclusions, like if you're in a domestic partnership, or if you're co-tenants, like if you both own the property together, but you're not related, and it's just two of you, that's a co-tenant exclusion. So you can avoid a reassessment that way. If there's no children, but there's grandchildren, then potentially you do a grandparent-grandchild exclusion. And then, of course, there's all kinds of business exclusions if which is a totally separate regimen of rules. If you have the property in a business, most people have property real estate in an LLC because that has usually has the best tax treatment. So um, so anyway, that's what you can do. Let's see, where are we at here? Uh, let's see, if I have a trust but can't find the original, can you make an amendment for me to attest to the photocopy of the trust that it's certified? Yes. So generally speaking, that's no problem. Uh, you know, and I've had clients do that all the time. And we just attach something that says I've lost the original trust, or I can't find it, or this copy is as good as the original. Never had a problem with that. Now there's some things you really shouldn't lose. You can lose your original trust, but really shouldn't lose your original power of attorney for finances or your original will. Those those things are much more difficult if you lose. Um, let's see, how long must the children live there? I think that was tacking on from another. Yeah, so under Prop 19, there is this kind of crazy rule that says if the child moves out of the property, then it gets reassessed. Um, so it's now I don't know how the county assessor is going to police that. Do they have cops that drive around from their office and check to see who's living there? I don't know if they really thought this law through very well. It's kind of new still. It's just 5 years old, and I don't know, I think a lot will have to play out on this. So let's see. If I only have hundreds of empty land in another state, would I get a living trust or will for my nieces to inherit? I have no children. So I would say, you know, that all depends on the value of the property and also what state you're in, what state that's in, because if it's a state that, listen, most other states other than California have a much easier probate process. And it might be just easy to go through probate in that state because it'll have to go through probate in the state where the land's located. So it might be no problem. But if it's worth a lot, if that property is worth a lot, no matter what, I would get a trust just because why send it through probate if it's valuable? Okay, next question. We have two adult children in 34, 45 age with no spouse or children. Uh, I'm still on each child checking account. I'm wondering if that will complicate their banking if I die or need a conservator. Yeah, your children could grant you a power of attorney. It all depends on how much they keep in their account as well. If the account's relatively low in value, like under 15,000 or so, then maybe it's not a big deal either way. Um, but it is, if the account is quite big in value, you start running into potential gift tax issues or creditor issues if your name is sitting on their account. So it's better to just be registered under power of attorney because that shows that it's not yours and and all that. In terms of how the IRS deals with this, they look at state law, but generally speaking, if you have control over an asset, a lot of times, if you have carte blanche, you're not a fiduciary, you can just get into that account and use the money. They will say it's yours. So you have to be careful about that. If it's just my husband and I, do we need to have a living trust? So not really. I mean, you could do without it. And you could make simple wills, and if you're leaving it all to charity, you could just say, "Hey, charity, here's my will when I die, and whatever. I don't really care." Um, but you are creating a little bit of a hardship for whoever gets your assets if they have to take it through probate first. So it might be a nicer thing to do, set up a trust. So, but it's up to you. And it also depends on what you own. If you're renting and you just have financial accounts, you could just do pay on death and then handwrite a will for your personal effects in your car. That's easy. That works. But you don't need a trust in that situation per se. Now, if you're leaving it to like a minor child or if it, that kind of situation, then yeah, you probably need a trust. Let's see. I'm getting married soon. We will have a blended family with our adult children and minor grandkids. Yay. We want to be sure that each of our children are treated well. My parents are still alive and I will inherit money when they pass. If I'm married when my parents pass away, what control will I have over the inheritance? Uh, let's see. Well, uh, if the inheritance is from your family, from your family line, I guess it all depends on how your parents leave the inheritance to you. They could leave it to you outright. They could make you the trustee so that you're in charge of everything when they pass. So it all depends on them. As far as a blended family situation, yeah, that's you and your spouse making sure you set it up the right way so there's protection. And what I recommend is a AB trust. That's a trust that splits into two shares. When the first one of you passes away, the trust just splits into two shares, the A side and the B side. The A side is the surviving spouse's side, the B side is the deceased spouse's side. And the B side can't be changed easily or at all by the surviving spouse. And that protects the children of the deceased spouse. So I think I answered your questions, but if I didn't answer that question, Deb, feel free to clarify. Do you work with a CPA that you can recommend? Yes, there's several CPAs, and if you want to go ahead, Kathy, you can email me and I can send some recommendations over. My email is Eric, ERIC, at PacificCoastLegacy.com. George says, AB trusts were used long ago. Is there now a better way to accomplish the same thing? So AB trusts were used for estate tax avoidance a long time ago. And when I say a long time ago, they really started phasing out, I would say, as of 2012. They really started phasing out a lot. And but there's still a place for them, for people who have, I would say, over $15 million, there's still a place for them. For people who have blended families, there's definitely a place for them because, like I just talked about, we need an AB trust to protect the children of the deceased spouse, the one who dies first. But let's say you're not, let's say you're kind of close. Let's say you have a 10 million estate and you're you're not sure what's going to happen with the estate tax exclusion. You want to keep it simple between you and your spouse. Um, Congress did come up with something called estate tax portability. This was around 2012, and they basically made it so that you can take the deceased spouse's unused exclusion amount and tack it on to your own by just filing some paperwork after the death of the first spouse. And that way you can avoid having an AB trust. You can hold everything in your own trust. You can transfer everything to the surviving spouse. When you pass away, surviving spouse has it and controls it all. There's no need for an AB split of the estate. But you then would have to protect yourself and file for portability. And portability in that situation, the government generally gives you 5 years to file, unless they determine that an estate tax return had to have been filed anyway. In that case, you have 9 months to file after the death. Most people, though, if they're under the exclusion amount and the filing requirements not needed, you get the 5 years. You can file late. Okay, can you give an example of how the dollar amounts would play out to a child inheriting my house if it is in a living trust versus not having a living trust? Yeah, so let's say you spend $3,000 to $5,000 with an attorney setting up a living trust. And then let's say you spend another $5,000 to $10,000 with an attorney settling the estate after you die. So you spent, I don't know, between, I don't know, $7,000 and $15,000 on attorney fees to do it privately. It went real fast. Um, you know, it was peaceful, it was controlled, it was planned out. That's if you have a lawyer do the planning and the estate settlement for you. Some law firms charge a lot for estate settlement, and some don't. So you have to shop around sometimes when you do estate settlement. Some try to charge big bucks for estate settlement, and doesn't have to be if it's not complicated. Um, so yes, now if it goes through probate, okay, then maybe you spend hardly any money writing a will. That same house, if it's worth $1 million, like I was saying, the fees on that to do the probate could be anywhere between $25,000 to $50,000 or more. If the house is worth 1.5 or $2 million, I mean, you're looking at even more money. And then it's caught up in probate for about a year at least. So I think, if you want to save your family money, sure. Find a lawyer who can administer it efficiently after you pass away. That's not going to charge a huge arm and a leg to your family. There's still work to do. There's still estate settlement work to do, but it doesn't have to be egregiously expensive to get that done. I mean, when you do it privately through a trust, you still have to follow a lot of the same steps that you follow when it goes through probate, but it's just being handled privately. There's no court overseeing everything. So there are chores to do, but it usually works out a lot cheaper. Now, the only time maybe when I would say purposefully send it through a probate court is if you have a very contentious family. You know, maybe send it through the probate court so that the court could oversee your family. Or have a third party trustee like a trust company handle it so all your kids can hate the trust company jointly, and then they'll have something in common with each other. So one of those two options. Okay, let's see, Deb, what do you recommend in terms of estate planning for people who are marrying in their golden years? Prenup, joint trust, other. I kind of recommend a prenup. I don't do them, but there's specialists here in the South Bay who do them. But I do recommend a prenup because you really got to plan out. You should privatize your split. Um, it's just smart to do that. And if somebody gets offended at a prenup, then they probably are not a good choice to marry anyway. Let's just be honest. They're going to probably create more problems because they're offended at it or they take it personally. But there has to be a practical side of people because you have this giant life, you have this long life, and all these people you cared about that you brought into the relationship. And, of course, you want to take care of everyone, including your new spouse. And you can do your planning in a way that totally sets them up for the rest of their life, takes good care of them. Um, so, I think there's a way to balance it out. Now, if you're younger and you're getting married for the first time and you have substantial assets, prenups are probably a good idea even then, especially if one has a lot more than the other. But you could always phase out the prenup. The plan could be like, hey, let's just see if we have a stable relationship. Let's see if we make it a few years first, then I'll get rid of the prenup or phase it out or change it. I don't believe that it's a nice thing to, especially if you're young and starting out, to just kind of exert all this control over your spouse through a prenup. But I think when you're older and you get married and you have a prenup, you're just respecting your children and your past life. And it's a very different situation at that point. Um, is there a lawyer needed to do a prenup? Uh, yeah, you shouldn't try to do it yourself. It's that's that's a tricky situation to try to do a prenup yourself. Uh, I recommend Colin O'Connor. He's in the South Bay. He's in Redondo. He's a good lawyer. Also Wendy Jones in Torrance. They're both good lawyers who've done a lot of prenups. Okay. Here's another, I guess the last question is, I have a son who rents out our back house. Does that qualify as living in the house that I live in now that he will inherit? Well, I guess the question is that back house on the property tax rolls, or is it just kind of like, you know, just the back house? Okay, it's on the property tax rolls. Um, so there is yeah, okay, good. Someone put Colin O'Connor's info. Yeah. Uh, yeah, there's definitely like a law with this parent-child exclusion that says that if there's multiple units on a property that parent-child transfer doesn't apply to the whole property. So I think if you're trying to transfer the house to your kid, that you want to say that the parent lives in the biggest part of the house. The kid's going to live in there too. When you file the Prop 19 parent-child transfer, and then just make that happen. And personally, I don't know if I'd mention the back house. If I filed the paperwork, I know this is being recorded, so I'm probably hanging myself right now, but um, I would, I would probably, I don't know. A lot of us have little bonus rooms and all that. We're not even really renting them out. It's not considered um, a separate unit or something. Uh, but yeah, I don't know. I guess technically, and this is part of the new Prop 19 rules, you have to kind of you could get reassessed on part of the ADU or whatever it is. Yeah. So if it's an official place you're renting out on your property, that may not escape the property tax reassessment. So it's up to you. I'm not going to tell you how to handle that situation. You'll have to kind of deal with it on a case by case basis. Um, yeah. So I think that's about it. Uh, any other questions, or are we good?
Any other questions, feel free to put them into the chat. Thank you so much, Eric, for your time and your expertise on this matter. Let's see. Yes,
I
thank you.
I do have a question. Can I just ask since I'm on?
Sure. Yeah,
Okay,
go for
so um I was the one that put in the question. It's just my husband and I, and we do have one property together. There are no children. So we just have everything as beneficiaries and just a simple will. Do we need to get a trust?
If you have your powers of attorney set up, your advance directive and your financial power of attorney, I uh, I would say you don't need one, if but like you also want to make sure you check how you are on title to your house. If you're
Oh,
on title,
yeah, we're both on the title.
yeah, so if I were you, I would make sure you take title as community property with right of survivorship, those specific words. Because that'll do is when the first one of you passes away, it indicates that it's community property and that it all goes to the surviving spouse with no strings attached, and by simply filing an affidavit, which an estate lawyer could help you do. It's very simple, very, very simple and inexpensive. Um, but filing that affidavit on title will clear the title and give the surviving spouse, full control without any probate or any kind of court procedure. And then the surviving spouse can also sell the property without a tax basis, without a capital gain, because they've said on title, this is community property. So that means it gets a complete tax basis adjustment. And that's a good tax result as well. So if you are trying to kind of keep it simple and not have to worry about a living trust, yeah, hold title as community property with right of survivorship. And then maybe the surviving spouse can make a trust at that point, assuming they're competent and can still do that. And then they can leave it to whoever they want. And that's kind of the simple, easy way to deal with it right now.
Yeah,
If you're worried, yeah. So
but it wouldn't go through that probate or a reassessment. The property that we both own would not go for a reassessment or probate.
not at the death of the first spouse. It would at the death of the second spouse.
Gotcha. Thank you.
Uh-huh. Sure.
Thank you so much, everyone, for attending, and Eric again for your time.
Yeah.